Good evening. Welcome, welcome, welcome. My name is Casey Ferran McGee. I'm the owner of CFM Media, a media coaching and consultant firm here in New Orleans, and I'm a former news reporter and anchor with WDSU News. I am honored to serve as the moderator of this webinar, which is sponsored by the Crescent City chapter of the Links Incorporated, a national women's organization devoted to enriching the lives of African Americans. Tonight's important topic is wills, an essential tool for succession planning. This webinar is the second in a series of webinars sponsored by the Crescent City chapter and is also a continuation of the first webinar entitled What You Need to Know About Succession Planning. Now, for anyone who is planning to make a will or who just wants to be prepared for handling the disposition of their property prior to their death, this is a very timely subject. Now, before we begin, if you have not already done so, please take a moment to complete the pre-survey that is going to appear on your screens here now. Now, these questions are going to help us get a little more information about those of you who may have been with us for the previous webinar, and also help us plan future webinars here in the next coming months or in the next year. So take a moment to take that poll. And while you're doing that, I do want to give you a little more information about why this topic is so important. According to a CNBC article published just last month, more than 70% of Black Americans do not have a will. That's 70% of Black Americans do not have a will. Now, what that means is that Black Americans are missing out on the largest wealth transfer in their history. Without a will, there is also a lack of clarity around a loved one's wishes. And it could also lead to potential discord among family members. And there's also the issue of what to do with property that may have been in the family for a generation or decades or even more. Now, as an added resource tonight, we will have a glossary of terms that will appear as a link in the chat box. So from time to time, you may hear some terms that may sound unfamiliar, but we have a glossary there that'll help you understand what these terms mean. We want you to really be clear about what we're talking about tonight. Now, time has been allocated to respond to any questions you may have, because I'm sure there will be a few, but please post those questions in the chat box or in the Q&A section at the bottom of the screen here on the webinar. And we'll get to those questions at a midway point to answer any of your questions, as well as at the conclusion of the presentation. Now, I'd like to introduce Ms. Tracy Boutte, the president of the Crescent City chapter of the Links Incorporated, who will be bringing greetings on behalf of the members.
Good evening and welcome. Crescent City chapter of the Links Incorporated is proud to be able to host a series of webinars for our New Orleans community focused on the fundamental processes of heirs property. The Links Healthy Homestead Initiative is one of the newest initiatives in our National Trends and Services facet and is designed to address the lack of knowledge surrounding heirs property in the African American community to assist in closing the gap on long-standing racial inequalities. Our goal is to provide integrative programming to educate African Americans about the issue and impact of home ownership and heirs property, while providing information and resources to protect family-owned real property. We hope tonight's session helps to expand your knowledge and awareness of legal processes associated with wills, an essential tool for succession planning. Please be sure to provide us your feedback as we continue planning for future webinars in our Healthy Homestead series. Again, thank you for attending tonight.
Thank you so much, President Boutte. We are looking forward to having this conversation tonight. Now we will hear from Associate Justice of the Louisiana Supreme Court and a former president of the Crescent City chapter, the Honorable Piper Griffin, who will introduce tonight's presenter.
Thank you, Casey. I have the pleasure of introducing our esteemed presenter and one of our own Crescent City chapter members, retired Orleans Parish Civil District Court Judge Carolyn Gill Jefferson. Judge Jefferson served as an Assistant Attorney General for the state of Louisiana and as a managing attorney for the New Orleans Legal Assistance Corporation. Currently, Judge Jefferson engages in the private practice of law and serves as a professional mediator, special master, and judge pro tempore. In addition, she is an adjunct professor of trial advocacy at Tulane University School of Law. Judge Gil Jefferson's tenure on the Civil District Court bench and her private law practice have provided relevant experience and insight into the legal process of wills and succession. She's a subject matter expert on Louisiana inheritance law and property law, as well as legal rights. We welcome retired Judge Carolyn Gil Jefferson and look forward to her presentation.
Thank you, Justice Griffin. It is a pleasure to join you all tonight, and welcome to those who have not joined us before, and welcome back to those of you who joined us in our webinar in December of 2020. I will review a few of the terms that we used in the successions webinar because they are going to be important in our discussion tonight. And we will begin with those terms to remember as we describe them. First is succession. The succession is the legal and orderly transfer of the property and debts of the deceased person to those who may inherit it. A testate succession, a succession guided by the deceased person's last will and testament. An intestate succession, a succession guided by the law. That is, the deceased person died without a will, and the law establishes the order of persons who can inherit. A testator. A testator is the person who makes a will. An estate, the property, assets, and debts that a person leaves after his death. An executor or executrix is the person designated in the will by the testator to distribute the property to the persons designated in the will. Next slide, please. Now, there are a few notes that we're going to govern ourselves by tonight. The first is that all of the content presented here is for informational purposes only. For legal advice, please consult an attorney. And all information presented here is only applicable to Louisiana. If you have not already done so, please complete the pre-event questionnaire. Again, I invite you to put your questions in the chat box. We will have a break in a few moments after going over some materials for you to ask your questions. Again, it's my pleasure to be with you tonight. Tonight's focus, as I said, will be on wills. And during the course of the presentation, you will hear the pronoun his. Please rest assured that it includes all persons. The first question we're going to ask tonight is, what is a will? Now, Louisiana law describes a will as a donation mortis causa. Now, a mortis causa donation is one that is made in contemplation of death. Thus, the last will and testament. The donation only takes effect at the date of death of the donor. And in the will, the donor disposes of all or part of his or her property. The donation mortis causa, that is a will, is revocable during the lifetime of the donor. That means that they can change it at any time should they desire to do so. And a will is commonly referred to as the last will and testament. Next slide, please. Who can make a will? All persons have the capacity to make a will. Now, there are some requirements as it relates to capacity. The first one is an age requirement. A minor under the age of 16 can only make a will in favor of his children or his spouse. A minor who is 16 years of age or older, but not a major, can also make a will. Mental capacity. Mental capacity refers to the ability of the testator to be able to comprehend generally the nature and the consequences of disposing of his property. Now, the capacity to make this will must exist at the time the testator executes the will. That means he has to be of the appropriate age and has to be able to generally understand the consequences of making a will and what that means as it relates to disposing of his property at the time of death. Next slide, please. Who can receive from a will? All persons can receive from a will. They must exist at the time of death of the testator, and unborn children in utero at the time of the death of the testator, and the child must be born alive. Mental capacity has no impact on the ability of a person to receive from a will. And when we refer to children in utero, that refers to children who have not been born and the mother is pregnant with the child. But that child must be born alive in order for them to inherit from the will. Next slide, please. Now, there's a topic called forced heirship, and I want to give you a little bit of history with regard to forced heirship. Prior to 1995, all children, regardless of their age, were deemed to be forced heirs. And what forced heirship also requires is that the parent leaves a specific portion of their property to their children. So in October the 21st of 1995, the Louisiana voters approved an amendment to the Louisiana Constitution abolishing forced heirship. However, the amendment also required the Louisiana legislature to establish a uniform procedure for handling the rights of heirs and legatees at the time of the person's death. And that applies in both testate and intestate successions. And as I said, tonight, we're going to be talking about wills. So what the legislature decided to do is to classify certain persons who could be forced heirs. And if we could have the next slide, please. Who are forced heirs? Children who are at the time of the death of the decedent are 23 years of age or younger. So if they're 23, haven't reached their 24th birthday, they are considered forced heirs under Louisiana law. Now, children of any age who, because of mental incapacity or physical infirmity or permanently incapable of taking care of their persons or administering their property at the death of decedent, are always going to be forced heirs at any age, whether they are 23 years or older. If they are suffering from some mental incapacity or physical infirmity, makes them permanently incapable of taking care of their persons, they are going to be forced heirs. Now, the physical and mental incapacity must be established by medical evidence. Next slide, please. What can forced heirs inherit? As I told you, an estate of a deceased person is made up of all of the property, the debts and assets of the deceased person. If there's only one forced heir, then the testator has to leave 1/4 of the value of that property to his forced heir. If the decedent has two children or more, he must give 1/2 of the property to his forced heirs. If there are no forced heirs, then the testator may leave all of his property to anyone. There are no limitations on who he has to leave the property to. Next slide, please. Before we get into the specifics of wills under Louisiana law, I want to give you just a few general principles about wills. An agent cannot execute a testament for his principal. So for instance, if one has the power of attorney for another, he cannot execute a will for that person using his power of attorney. Only one person can execute a testament in the same instrument. For example, there are no joint wills. Husband and wives cannot make a joint will. They each have to make their own separate wills. And the testator can give his executor specific authority to give specific assets to specific persons or entities. And Casey, before we go on, are there any questions that we have at this point?
It looks like we don't have any right now, but I definitely have some prepared for you as you continue on.
Okay. All right, well, we'll move to the next slide then. Forms of testaments or forms of wills, what do they look like in Louisiana? The first form of wills in Louisiana is an holographic will. And an holographic will is one that is entirely written, dated, and signed in the handwriting of the testator. The date can appear anywhere in the testament, and the signature of the testator must appear at the end of the testament. So what you have here is a individual can take a sheet of paper, sit down and write out what the specifics of his property disposition is going to be. It has to be in that person's handwriting. They have to date it and they have to sign it. It's not necessarily important that the date be at the top of the will or at the end of it. It just has to be on it. And the signature has to appear at the end of the testament. Next slide, please. The next is the notarial will. Could you go back just one more slide? I think we're a little ahead of ourselves. All right, thank you. A notarial will, that is one that is entirely typewritten, it's dated, and it's signed by the testator. Now that will has to be executed in the presence of a notary and two competent witnesses. The testator must declare in that instrument that it is, in fact, his last will and testament, and the testator must sign at the end of each page. As you can see, there's a huge difference between the two. In the notarial will, it must be typewritten, it has to be dated, and it has to be signed by the testator. And it has to be done in the presence of the two competent witnesses. You can't have the testator sign one time and then the witnesses sign at another time. They must all be present when the will is executed by the testator, and the testator must sign at the end of each and every page. Next slide, please. Okay, if you go back one more slide. Forward one more. Okay. Now, next, what individuals can execute a notarial will? Well, the person has to know how to sign his name, read, and physically able to do both of those. A person who knows how to sign his name and read and is physically able to read, but unable to do so because of a physical infirmity. And a person who does not know how to read or his inability to read is due to a physical impairment. And the person can execute a will if he knows how to read Braille. And a deaf and blind person can read if he is able to understand what the terms are. So let's kind of go back through these. So we'll be clear about what it takes to execute a will. The first one is fairly easy. A person knows how to read and sign and physically be able to do both. But in the second one, it says the person knows how to sign his name and read and is physically able to do so, but unable to do so because of a physical infirmity. This generally happens in an instance where the person has suffered some kind of injury and has some physical infirmity that does not allow him to be able to read, unable to see temporarily because of some injury or infirmity. And as the third one says, he knows how to read, but he's unable to read due to a physical impairment, not able to see at the time he is executing the will. And of course, if you can read Braille, you can execute a will. And if you're deaf and blind, as long as you're able to get sign language to be able to tell you what the contents of your will are and have a translator there. Next slide, please. What do you put in a will? Well, it is made up of bequests to individuals or groups. You can give away all or part of your property. You can direct how any final debts that you may have are paid. You can name your executor and an alternate executor, and you can name an attorney to represent the executor and the succession. And as I said, the first one says you can give your property to whomever you want to give it to. Of course, you have to keep in mind whether or not you have persons who would be forced heirs. And as I said, you can give away part of your property or all of your property. That is strictly up to the person who is making the will. You can direct how your debts are being paid. You can direct that your debts be paid from the mass of your assets, or you can direct that the person who receives the particular item pay any debt that is associated with that piece of property that you're leaving them. That is strictly up to the testator, how he wants to direct how his debts are paid. You get to name an executor and an alternate executor. The executor is generally a person that you trust, that you have some faith in, that will handle your property after you're gone. And you also get to name an alternate executor. If for some reason the person that you name as executor is unable to serve or chooses not to serve, you will have it already noted in your will that who the alternate person is. And you can name an attorney to represent the executor and the succession. That is, again, is strictly up to you. However, there's been some recent case law that has held that even though the testator has designated a specific individual to represent the executor and his succession, the executor can make a change in who the attorney is going to be to represent the executor and the succession. Next slide, please. Can a will be changed or revoked? Yes, it can. The testator may revoke his testament at any time. As long as he is alive, he can revoke it and or change it. Now, how do you revoke your will? Well, you can first just tear it up. It says physically destroy the will or direct someone to destroy it. The second method is to execute another will and specifically say that he is revoking any previous wills. And thirdly, you can execute a writing in your own handwriting, sign it and stating that he is revoking the will. Next slide, please. Can a will be challenged? Yes, it can be. And generally, the two ways that people are challenging wills, they challenge a will based upon, number one, the capacity of the testator and the validity of the form of the testament. When we're talking about mental capacity of the testator, we're asserting whether or not the testator understood what he was doing when he made the will, whether or not he was suffering from some mental incapacity or some mental infirmity that he would not understand what he was doing at the time when he executed the will. The validity as to the form of testament. And the form, as we talked about earlier, the holographic will must be a will that is written in the testator's own handwriting, dated and signed. If it's written in his own handwriting and not signed, then it is not a holographic will. It is not a valid holographic will. If the person types it out and signs it and puts a date on it, that is not a valid, is not a valid holographic will. With regard to the notarial will, if it is not executed in the presence of the notary and the two witnesses at the time that the testator signs it, it is not valid as to form. Those factors have to be present in order to be a valid will. And those are the two areas where people generally bring their challenges to a will. Next slide, please.
Judge Carolyn, we have quite a few questions for you. Do you mind if we pause here, answer a few questions,
Certainly.
and then jump back in? Okay.
Sure.
Casey, do you want to jump in?
Yes. Okay. So yes, you gave us so much information and we do have a lot of questions rolling in. So we want to get to the first one. Does the testator need to list in the will what he wants the executor to distribute?
Yes. when you make a will, you will say that, and this is the language that's generally used, I give and bequeath to Carolyn my property located at 1111 Two Rose Street. You can make that, your will be just that specific. Yes. And what the executor does, it is his job to make sure that Carolyn gets 1111 Two Rose Street. The will sets out specifically what items you want a particular person to receive after your death. And the executor has an obligation to do that. And we're going to talk about what are the duties of the executor are in a few moments. But the executor is bound to make sure that all of the bequests are followed through and given to the respective person who they have been bequeathed to or given to.
Now, we spoke a bit about forced heirship in the beginning. Are there any instances where I have the right to not leave anything in my will to a child under 23?
Yes, Louisiana law provides for disinheritance, and there are a specific number of factors that have to be in place in order to disinherit a child who is a forced heir. And one of, I don't have the full list in front of me, but one of the ones, and it makes sense, is if that child was involved or in trying to kill that parent. So that's kind of the one, but there are only specifics as it relates to disinheriting a forced heir.
Some other interesting questions came up. If the executor chooses not to do so, can the executor name a replacement?
The executor does not have the power to name a replacement. That's why I was saying a moment ago, when you execute a will, it's important that you name an alternate executor in case the executor chooses not to or is unable to serve as executor. And sometimes the executor may in fact have passed away. If that is the case and there is no named alternate executor, any one of the beneficiaries of the will can go into court and ask the court to appoint them, since the executor has chosen to decline his appointment and there's no alternate executor. And if the alternate executor decides, I don't want to take the job either, as I said, one of the beneficiaries of the testament of the will can go into court and ask that they be named as the executor of the will.
And then can one of the witnesses be the executor as well?
No. The witnesses generally have no involvement in the will. I have not seen instances where witnesses are in fact named as executor of a will. And remember, the executor, the testator gets to name the person to be the executor is a person whom they trust. And sometimes, depending, people don't want persons to know that they're in fact making a will, that they choose to have some unrelated persons or persons who are not acquaintances to be a witness in their will.
Okay, we have a few more questions. You spoke about it a bit, but how do we contest a will? What's the process to actually contesting a will?
Okay, first of all, before any will can be probated, we know that we have to, probate means that the will has to be presented to the court, and the court will declare that that will is, look at it and make a determination if it is in fact valid as it relates to form. And if there is a beneficiary of the will who chooses to contest it, he has to file an opposition to the will being probated in court, and then the court will set a hearing and make a determination as to whether or not that person's opposition to the will is valid under the law and make a determination after that. But you have to go into court. A will, just because you make a will and have it with your executor and whomever else you wish to give it to, it does not take any effect until it's presented to the court for probate. That is, that the court has approved of the form of the validity of the will, and that the executor can proceed with handling the assets of the estate of the deceased person, and assets as well as the debts.
Okay, I have two more questions for us here, and then we'll let you continue. What happens to the property if the person does not have children, nor do they have a spouse?
If the person makes a will, he can, as I said, dispose of the property and give it to anyone, including groups, corporations. Some of you may have heard where people, in fact, leave their estates to charitable organizations or individuals to whom they are not related to. But again, in Louisiana, you got to be careful and make sure that you are providing for your forced heirs. But if you do not make a will, and as I said earlier, that your estate will become an intestate succession. And the law sets up how your property is distributed if you die without a will. The first thing under the law is that, as you said in the question, there are no children, and there is no spouse. A surviving spouse is never an heir if the person dies without a will. So if you die without a will and you had no children, if you have siblings left, then your property would go to your siblings or any children of your siblings. If you have no siblings or no children of siblings, then it goes to your parents. And if you have no parents, then it will go to a surviving spouse under intestate succession. Surviving spouses, people tend to think they ought to be the person who inherits immediately if they're met. That is not the case. If you die intestate, that is without a will, your surviving spouse is further down the line. Now, you can leave property to your spouse in your will.
So what if there's no living relative? What happens to the
Well,
property?
if there's no living relative to present to the court, a person who has some interest in it, and I guess the question is kind of getting at what, and they've heard that your property goes to the state. Well, the state doesn't automatically get your property. The state does not go around trying to figure out what property is left available, that nobody has made a claim for it. The only way that the state gets an individual's property when they die without a will, when they die without any living relatives, is if the state has some kind of claim against it, i.e. that no real estate taxes have been paid on the property. And they will seize the property, sell it at a tax sale to pay the taxes. But that is the only way that the state gets to your property if you die without any heirs, and you die without a will, name specific individuals.
All right, and then I'm gonna ask this one last question. We'll let you get back to the conversation because I know there's a lot more to go, and I know more people will have questions later, but what is, just in general, what is a forced heir?
A forced heir is a child who is 23 years of age or younger, or a child because of a physical or mental incapacity at any age, who cannot take care of themselves, is a forced heir. Now, you have to establish that mental or physical incapacity by medical evidence. You just can't say, oh, he's mentally ill or she has a physical impairment that they can't take care of themselves. It has to be established by medical evidence. It's not automatic. Those are forced heirs. Those are the people where if you've got one forced heir, you have to leave them at least 1/4 of the value of your property. And if you got 2 or more, you have to leave the forced heirs at least 1/2 of the value of your property.
All right, that's all the questions we have for now. We'll save the rest for later and let you continue the presentation. Thank you.
Okay. All right, next slide, please. All right, my will is done. What's next? Well, once the will is executed, either in notarial form or it's executed in an holographic form, the testator always keeps an original, and an original should be given to your executor or your executrix. It's important because when the will is presented to the court to be probated, the court looks for the original document. Now, there are instances where the original document may not be found, and then you have to go through the process of having an affidavit, if you can, of the person who, if there's a notarial will, or you use a copy and present to the court saying this is a copy, and then you get affidavits of the person who can identify the person's handwriting in the case of an holographic will. Next slide, please. What are the duties of the testamentary executor? Well, the first duty he has is to act as a prudent, that is a careful administrator with respect to the succession. He has a duty to collect, to preserve, and manage the property of the succession in accordance with law. The testamentary executor can be personally liable for damages that result from his failure to act as a prudent administrator. And he represents the succession in making claims on behalf of the succession and defend against any claims made against the succession. He delivers the bequest to the legatees and he closes the succession. Let's go back over the fourth. He has the obligation to act as a prudent administrator. He has to take care of the property that forms the succession. He has a duty to collect it. In the collection process, making sure that he knows where the property is. If we're talking about houses, if we're talking about specific bank accounts, and he has to manage that property in accordance with law. And the law says that he has to, with regard to the bank accounts, he has to set up accounts in the name of the deceased person, to the estate of the deceased person. And if he fails to do that, to act prudently, he's personally liable for damages. Now, the executor or executrix is not personally liable for the loss of property unless he's failed to do something that would have preserved the property. For example, for instance, if part of the estate of the testator is a piece of real estate, and he neglects to put insurance or maintain the insurance on the particular piece of property. If that property is destroyed as a result of whatever, fire, hurricane, floods, whatever, if that property is destroyed or damaged and he has failed to maintain the insurance on that property, he can be liable for the damages to that property, and personally, it has to come from his assets personally for that. He represents the succession in making claims on behalf of the succession. For instance, if the testator was part of, say, a class action lawsuit, and the deceased person was a member of that class, he has an obligation to continue to make that claim on behalf of the state. Now, if someone he has to defend the succession against the claims that are made against it. The testamentary executor has the obligation to defend the will. If there is a contest, the executor is the person that has to be sued, and he has the obligation to defend the succession and the wishes of the testator. He has an obligation, and of course, this is the one that most people are looking for. It is deliver the bequest. That is the gifts that were made under the will to the person whom it was designated. And once he has done all of that, he has to make an accounting to the court and let the court know what property he received, what there were, if any expenses were made of the succession, and ask the court approve of his closing the estate. The court will sign off on an order saying everything is in order and will release him as the executor. Next slide, please. Thank you all for attending. I hope the information that I have given you has been helpful to you and that you are encouraged to go out and make your will. As we said, it is a tool in succession planning. It is a method by which the person who is making the will gets to determine how his assets will be distributed after his death. Again, thank you all for coming. I will answer any questions that remain this evening.
Yeah, we do have some more questions. Thank you so much, Judge, for that excellent and informative presentation. Next, I want to ask a question we have for what is the difference between a living will and a last will and testament? We kind of heard you use those a lot.
Okay, a living will is a document that the individual prepares to deal with the end of life care. It does not dispose of anyone's property. It gives directions to individuals or to doctors as to how they want to end, how they want their end of life to occur, whether or not they want to have extreme measures to prolong their life or that they want to limit their measures that are taken to prolong their lives. A last will and testament disposes of all of the assets, property, and debts of a person. So you're deciding what happens to your home after you die. That's what a last will and testament. It decides who gets your diamond ring, who gets your house, who gets any asset that you have. That's what a last will and testament does.
Okay.
It's a specific difference.
All right. Okay, so if there is no other person named in the will, and it's also the executor who chooses not to do so, who then becomes the executor?
As if there's an executor named in the will, and that executor says, for whatever reasons, I don't want to take on that responsibility. If the testator has designated another individual to be what we call an alternate executor, and he decides that he doesn't want to take on the responsibility, any person who is the beneficiary of the will can go into court and ask the court that they be appointed then it would not be an executor, because an executor is a term that is used for a testament. He would be an administrator. He would not be the executor of the will. He would be an administrator of the will to make sure that all of the bequests are done.
This is another question we received. Can a handwritten will be more than one page?
Absolutely. All you have to do is to make sure that it is written in the person's handwriting and that it is signed at the last page. It can be if you have a lot of property, it takes a lot of pages to get it all written out. So certainly it can be more than one page.
So we don't have to sign each page, just the last page on multiple pages?
No, not on an holographic will. You don't have to sign every page, but in a notarial will, you have to sign every page.
Gotcha. All right. If disinheritance only applies to forced heirs, is it a best practice to list in the will that you bequeath nothing to a specific child, regardless of their age?
Well, let's back up. Disinheritance does not just apply to forced heirs. You can disinherit any child. Any child can be disinherited, okay? It's not just limited to forced heirs, but there are specifics under the law that says to disinherit a child. And as I said, I don't have the list of them in front of me, but they are very specific. You can say in your will that you choose not to leave any a specific child any property. Again, remember that the last will and testament is whatever you decide to do with your property. That's the testator's decision and his sole discretion. He gets to make the call.
All right. Does the child of an heir get the same amount as the first line heirs if their parent is deceased? Does that make
I'm
sense?
not sure. Well, let me see. I think I understand what they're trying to ask. In Louisiana, we look at children as our descendants. And so if a child is born during the course of a marriage or is born outside of the marriage, Louisiana does not make a distinction between those children. So all children, if the person dies without a will, they inherit equally because that's what the law says. Now, if again, in the will, the person who makes the will can make a determination as to what he wants to leave to any specific child. And if he's, as long as there are no forced heirs. And remember, when you have forced heirs, you have to make sure that your children who are 23 years of age or younger or suffering some mental or physical incapacity, they get their specific portion. That means that you have to leave them at least 1/4 of your property. And if you got 2 or more children, you have to leave them at least 1/2. The other remaining parts of your property, you can give away to whomever you choose to. But as it relates to children, there is no distinction between, I think when you said first line of children, there's no distinction between biological children, whether they're born in or outside of a marriage.
Okay.
I hope that answers the question. And if the person who asked the question, if they need some more clarity, please put your question in the chat box and I'll try to clarify it for you.
All right. Is there a recommended way to relieve heirs of tax liabilities for inherited property?
Well, first of all, in Louisiana, there is no inheritance taxes. You do not pay any taxes on inheritance. So if you inherit a piece of property, there is no inheritance taxes due on that. Currently, there are no taxes due on estates where it is $5 million or less. You don't pay any federal inheritance taxes. Okay. Now, if you have a piece of property that you have inherited and you rent that property out and you get income from it, you will have to pay income taxes on that piece of property. But the actual piece of property that you inherit, there is no inheritance taxes on it.
Okay.
Both state, unless, as I said, in federal, if it's more than $5 million, then you're gonna have some inheritance taxes. That's the current exemption and it changes. But under Louisiana law, since Hurricane Katrina, you don't have any inheritance taxes.
Okay. So we have a couple more questions. Who is most often named as an executor?
Again, it's a matter of preference to the testator. People generally, they will name their spouses as their executor. They will name their children as executors, or if they have no spouse, or children, they will name a person who's a good friend of theirs. Again, it is solely up to the discretion of the person who's making the will. Again, I would urge it's a person who you trust and will make sure that your specific gifts to persons will in fact be delivered to them.
Okay. We have a couple more questions that came in just now. For clarification, if I die without a will, does my husband get half of community property with the other half going to our children? What happens to anything deemed to not be community property?
Okay. All right, let me start with this. There are 2 kinds of property in Louisiana between spouses. It's your separate property and your community property. Separate property never changes the classifications. So if it starts out as community, it's gonna stay community. If it starts out as separate property, it's gonna stay separate property. To answer that question, if you die with a spouse, as a matter of law, in an intestate succession, the person, your spouse owns an undivided 1/2 interest of the community property. The other the half of the deceased person is divided among the surviving children or the descendants of their children. So if you have property that is your separate property, neither spouse, and you can decide who inherits that separate property. All property that is inherited is separate property. So if you get married and your grandmother has left you a house, that house is your separate property. It never becomes community property. Y'all are taking me into another discussion, but it is important as it relates to wills. In an intestate succession, they get us a undivided 1/2 interest of the property. And in the will, a person can leave his share of the community property to his spouse, but that's only done by will. If you don't leave a will, the spouse will own, not inherit, own an undivided 1/2 interest in the community property. The other half goes to the surviving children or the descendants of their surviving children, deceased children, rather.
Okay, we have a couple more questions that just came in. What is the signature requirement of a will if the person has updated after it was notarized?
Well, if you're going to update your will, I think I understand the question. If you're going to update your will, you need to either execute another will if you want to add something to it. As I discussed earlier, you can always change your will, but if you've signed off on it, it's been notarized, the witnesses has signed it, you need to execute another will. If you forgot some bequest that you wanted to make to somebody, you got to go back and make another will.
Okay.
In order to convey it.
If I write my will in one state and move to retire in another state, must I write another will?
It just depends on whether or not that you don't have to write another will. If you lived in Louisiana and you executed a holographic will in Louisiana and you moved to Mississippi, because if it's valid under Louisiana law, it would be valid in Mississippi. Again, to be valid as an holographic will, it has to be in your own handwriting, has to be signed, and it has to be dated. But the validity will transfer from one state, but it has to be valid in the state that you executed it in.
All right, I'm going to ask if we have any more questions. Please go ahead and drop them in the chat. We have a few minutes left on this webinar, but one last one I do have is there a difference regarding same-sex surviving spouses' ability to receive in a will?
No, there's no difference. The Supreme Court of the United States in 2016 issued a ruling that made same-sex marriages legal in all 50 states of the Union. And so Louisiana does in fact recognize same-sex marriages. But again, in order for the property to go to a spouse, the spouse has to be in a will, the spouse has to be specifically named in it. And if the person dies without a will, the surviving spouse will receive their undivided 1/2 interest if they have a community property relationship. And there are instances where people do marriage contracts and they say we're going to be separate in property. But if there's a community property relationship, the person dies without a will, the spouse will own an undivided 1/2 interest of the property.
All right, that was our last question. Thank you so much for all that information. Is there any last thoughts you'd like to leave us with?
Well, as we said earlier, the title of this webinar is Wills, a Essential Tool in Succession Planning. It's important, as you pointed out, for African Americans, 76% of us do not have wills. And it's important in order to make sure that the property that you leave behind will go to your descendants or any person who you believe worthy to have it. So it's important that we do our will so we can make sure that there is an orderly transfer of your property. For many times, one of the questions, of course, asked about how property gets to the state. And because we don't leave wills, and because no one is interested in opening up the succession of a deceased family member who does not have a will, it's important that we do that to make sure that the property that our ancestors and that we as individuals have worked so hard for gets to those persons whom we deem to be worthy of it. It's been my pleasure to present this webinar to all of you this evening. As I said, I hope it has been helpful to you, and that for those of you who have not made a will, please consider it. And those who have made one, thank you so very much, because you contribute to making an orderly transfer of property. Thank you all again. And as I said, I hope it has been helpful to you.
We did have 2 more questions come in. Do you
I
want
will answer them.
Okay.
I will answer them.
Can you speak to the court costs and whether the executor is responsible?
The executor is not responsible for any of the costs, personally responsible for any of the costs associated with the probate of the will. Court costs can vary based upon the parish that you're in. Each parish has a different court cost set up. You do have to pay for the initial filing of the succession to include a will, and then after you have if there's real estate involved, you have to record the new owners of the property. So there's a cost that's associated with that. In Orleans Parish, the clerk of court has set, if an estate is worth $125,000 or less, then there's a fee. And if it's worth more than $125,000, then there's a separate fee. And then, as I said, there's a recordation fee, and it will vary based upon the number of pieces of property you have in the final judgment of possession. But again, the executor is not liable for those. Those fees are taken from the assets of the estate, and the executor has to account for the spending of those funds to do that. Because if you remember, I told you that the executor has the responsibility of assembling all of the property, taking possession of the bank accounts and the like, and then setting up a specific estate account. He can make those withdrawals to pay those fees. He can also make the withdrawals to pay an attorney fee for it. And the executors also get a fee for handling the estate. And I forgot to mention this, the testator can designate a specific fee for the executor, or as a matter of law, the executor is entitled to a 2.5% of the gross value of the estate as a fee for handling the estate.
And then
but the costs again vary.
Okay. This is a very specific question from Tyra. If I leave a vehicle to a child 16 years old who's not able to drive, can I designate the executor to be responsible for that property until the child is of age?
Yes, you can.
All right. And then where should we be storing our wills? Where should we keep them?
Well, some people keep them in safe deposit boxes. Some people have I guess containers within their homes that they keep them in, and that they're locked. It just depends. That's why I say it's important to give a copy of your will to the person that you've named as an executor. So there will be at least 2 original copies available. And when you go to see an attorney to execute a notarial will, make that request. Tell them that you want to execute multiple originals. So if one is lost, someone else will have that original will to be able to present it to the court for probate.
All right. Again, thank you for your amazing wealth of knowledge. As I mentioned before, more than 70% of Black Americans don't have a will. And most of us may actually remember when actor Chadwick Boseman died, he didn't have a will. Neither did recording artist Prince or Aretha Franklin. So this is something that we all want to be tending to. And this has certainly been a very informative session. Of all the terms we learned tonight will be in a glossary that have been sent to you in your emails. If you registered with an email, you will get that glossary sent to you, so you'll have more information as you begin to plan for your succession planning. And we hope you've gained the knowledge and tools to do so. Hope that you and your families are better equipped to make these important decisions. And we thank you all for joining us tonight. And remember to look for future webinars on other important topics of interest to the greater community. In closing, we would like to thank the Crescent City chapter for planning this webinar. A special thank you to our presenter, Judge Carolyn Gill Jefferson, Chapter President Tracy Boutte, Honorable Judge Piper, Angeline Jefferson, and to the webinar committee members led by Chair Danielle Wright. And to those who participated in the webinar tonight, we greatly thank you for your time and your attention and your amazing questions. We look forward to having you join us on the next webinar. We hope you all have a good night. Thank you.
Thank you.